for the opportunity to address you one last time on behalf of the state of Ohio, citizens of the state of Ohio, and our Cuyahoga County prosecutor, and the team that was present with us throughout the trial here, Your Honor. Only Brelo, only the defendant, can be held responsible, Your Honor, for these actions. And I hope that through my recitation of the facts, we'll be able to explain a number of things, and perhaps disabuse some of the things that were said by defense counsel during their closings. Brelo can be responsible for these lethal downward trajectories that killed Timothy Russell and Malissa Williams. Through the state of the evidence, that is, during the state's case as well as the defense's case, no one else was in these upward positions. Even the defense, asking their own expert, Dr. Rowe, that certain bullet wounds can come from both the hood of the Malibu and the zone car. These lethal shots from these elevated positions, by their own questioning, are for Malissa Williams, 9 and 10, and 12. That's from Dr. Rowe herself. And Timothy Russell, 15A, C, E, F, G, H, and I. The state's position is that Brelo is responsible for all of these lethal ante-mortem downward shots that have been presented for the court, also presented in mannequins before the court. That includes both wounds 1 and 2 on each of the victims, and Malissa Williams, 8, 9, 10, 11, 12, and 13. All of the ante-mortem lethal wounds that are in a downward trajectory, Your Honor. And for Timothy Russell, the combination of the wounds A through I, Your Honor. Brelo is also responsible for other downward shots in both of the bodies that are pre-mortem but are not lethal. These shots can only come from the elevated positions, all of which the state's position is that the defendant acted unreasonably without probable cause. Brelo was on the hood. The audio experts, Maher, Koenig, Beck, and the defense's own expert, Stutchman, all agree that the last sequence of shots, the 15 gunshots of the last 18 sounds, are from one gun at one location, shooting in one direction. Officer Brian Sobolik sees the defendant, Brelo, shooting from the windshield of the Malibu in a downward position into the Malibu. He demonstrated for the court, and I would suggest this is a steep downward trajectory position in which he presented the court in the testimony. It's consistent with Dr. Filo's explanation of how these wounds on Timothy Russell were in fact a steep downward trajectory, including the state's exhibit here, the mannequins, the 15A shot that goes straight down in a steep position. He demonstrated for the court, and I would suggest that steep downward position, Your Honor, is so close to the windshield that it would be difficult to miss. That was brought out in examination of Mr. Martinelli, the defense expert himself. The defense trajectory expert, Mr. Martini, report is also in concordance with the wound paths that have been demonstrated, testified to by Dr. Weems and Filo, as well as the mannequins that are here. For the record, Dr. Weems said that bullet number 2, the bullet path here on the mannequin, was actually in a steeper position. Martini, working with Posey, as he says in the Martini report, and after providing information to Dr. Rowe, made some determinations about these wound paths. Mr. Martini testified on cross that based upon a reasonable degree of scientific certainty that Brelo was on the hood for the last 15. That's page 3,720 on the transcript. Again, based upon a reasonable degree of scientific certainty, Ms. Barnhill asked, and he acknowledged Brelo was on the hood for the last 15. Also, remember the testimony, Your Honor, regarding the 3 shots within the 18 sounds and how there was some disagreement about those shots, if they're shots or echoes, other sounds. Martini, his testimony supports the state's position, again, that Brelo was on the hood during this period of time. If you believe all of the information that the defense put forth from Mr. Stutzman and the cross-examination of state's experts, that the other 3 sounds are shots that are being fired during Brelo's shooting. First of all, Brelo never said that he heard it. An important point that goes to whether or not he believed that he had to continue to act unreasonably. More importantly, the defense expert solidifies the defendant was, in fact, on the hood shooting. Martini says on page 3712 to 3713, in answer to the court's questions about what he bases his opinion on, he said he based it on his review of the audio recording results as analyzed by several experts, 2, as well as the physical evidence associated with the Malibu, and 3, as well as the downward trajectories to the occupants. And in his opinion, if the 3 inconsistent shots on the dash cam recording are shots by another or other shooters, then Officer Brelo would have been on the hood of the Malibu when these 3 shots were fired. Again, with your patience, 3712 and 3713, Your Honor. The hood. He has reloaded on the hood. That's the state's position. These 16 shots, 15, plus that earlier shot, the last shot of the first barrage, the middle shot, event 0. There are these all in explanation. They're from a different position from the earlier barrage. That's the state of the evidence. That's what the experts testified to. None of the earlier shots, other than Mr. Beck explaining that 3 of those earlier shots, in his opinion, were from the same shooter. But Koenig, Maher, Stutzman, none of them could say that any of the earlier shots from the first series are in fact Brelo. But those 16 shots are. That's important. It's important evidence for the state to present it to the court because it explains that Officer Brelo was in a different position than he was before. Even their own expert, Mr. Stutzman, explained that Brelo can reload during that 2.6 seconds. And it's ridiculous to believe that he did an administrative reload. That's that extra bullet you put into the gun. Although there was some testimony about that, that just defies all common sense and logic. There's 2 left in his magazine. Final 15 shots that are heard are the final 15 shots, or the first 15 shots in his last magazine. Martini explained in his testimony that Brelo was on the hood. He's shooting exclusively at the end of that first series. He reloads and he shoots more, 16. Let's look at the timing, Your Honor, whether or not the victims at that point in time were alive, because there was some question and there was some testimony regarding this. Wound 10 is caused when Brelo, from his elevated shooting position, shot through the A-pillar. According to the testimony from Dr. Philo, that wound by itself, the victim would have survived 2 to 3 minutes. There's also blood loss that's been found in the cavities from all of the wounds. And as Dr. Philo explained, that you'd live up to 20 seconds after she was shot this Malissa Williams, when the blood was retrieved from her. Timothy Russell was also alive. His heart was beating as well, according to Dr. Philo and Dr. Weems. There was blood in his cavity as well. The shot to his brainstem does not end life immediately. The heart can still beat. We know he was shot in his heart, and his heart continued to beat because of the blood collected in the cavities. And, Your Honor, we showed you pictures from the scene from State's Exhibit 144 and 145 that are consistent, according to Dr. Philo, with blood loss from the head, where the blood would have pumped up north. It would have been pumping against gravity. More evidence or indicia of life besides the blood in the cavities that he spoke about. His testimony was very succinct, very deliberate. Questions were asked, was Malissa Williams alive during shots 8, 9, 10, 11, 12, 13? The answer is yes. How long was the shooting? The testimony from Dr. Marr, and there's spectrographs that are included in his testimony, as well as the exhibits that are in front of the court. From 9:41.3 to 10:01.029, there are 20 seconds of shooting. This second series, or second barrage, as Dr. Maher explains or characterizes it, it's from 9:56.087 to 10:01.029. That's 5 seconds. And 2.6 seconds to reload. So that's 7.6 seconds plus the 1.6 back to the last shot of the first series that all of the experts testified is consistent and is, in fact, based upon a reasonable degree of scientific certainty, Brelo's. So 7.6 seconds, including all of those final 16 shots. Those are the final 16. They're all levied within 7.6 seconds. Dr. Philo said Malissa Williams could be alive to up to 20 seconds after this A-pillar shot and the other injuries collectively together. Dr. Weems testified that Timothy Russell could be alive for 2 minutes after shots 15B and D. 15B and D. And could be alive for 30 to 45 seconds after the 15 series. This barrage, first and second series, all occurred within the time limit for them to be alive. No one else but Brelo could be shooting those final 15 of 18 gunshot sounds, Your Honor. Sabolik's testimony, Moore with 19, but she reloaded, and there's 8 through her windshield. The audio experts agreeing, Marr, Koenig, Beck, Stutchman. One gun, one location, one direction. From his own statement, we know that the defendant was at the bumper when he reloaded. He says that's the second time that he reloaded, but we know that that was the first time from the casings, Your Honor, that have been found in the area. There's not enough casings in this confined, contained area to belong to the defendant. And there's lots of casings that are on the other side that would all be consistent with him shooting from the elevated positions. Could he have fired 17 plus 15, 32 from these 2 elevated positions? Yes. The bullet holes in the windshield, Your Honor, there's more than enough for him to have fired those and hit the windshield. The total casings and the group of casings that we talked about support this. The second barrage does not match that first barrage. So we know that he's changed his position significantly. BCI crime scene report, Your Honor. As the court recalls, when the experts, Dan Wintrick and Brenda McNeely, did their work on the car, they put stickers on the car. They looked at the trajectories, not only of the trajectories when they had 2 points of reference, but also the doubling on the windshield bullet holes themselves. And they were able to affix a position to each one of those. The lower 1 o'clock positions are consistent with Brelo shooting behind the bumper. And the court has information, testimony from Special Agent Soraya about where the defendant was at that position and how he could not get through the engine. He changed his positions. The testimony, there's a clock here for demonstration purposes, from the special agents who did the reconstruction work, is that it's from inside of the car. So things that are looking from inside of the car, the windshield, where the occupants were, side of the fishbowl, they're looking out, and to their right is 2 o'clock. 1 o'clock, 12 o'clock is the middle of the hood in front of them. The BCI report, which is an exhibit for the court to see, explains what all the 2 o'clock positions are, with trajectories and with doubling. The highlighting has been done here in yellow for the court for argument. These are the different 2 o'clock positions listed in the report. When we take the 2 o'clock positions, Your Honor, and we place them on and highlight the actual stickers, we can see that the defendant, Brelo, is in fact transitioning his shots and attempting to shoot both of the occupants of the car. His statement said as such, as he went up the hood, up on the trunk, and as he was shooting, he was transitioning between the two. And in fact, you can see the A-pillar and how the 2 o'clock position is noted there on the A-pillar. This is the 2 o'clock again to 8 o'clock position from looking inside to out. It's the other side of the windshield. There's one other 2 o'clock position. These are in yellow, those 2 o'clock positions from the ballistics report of BCI. The trajectories, the angles, if you will, Judge, are in fact very similar. The top one is the A-pillar. That's bullet hole 7. It's a negative 21 degrees, very similar to the other A-pillar that penetrated but did not perforate. 22, 19. We got the rear view mirror shot, 14. These shots and the trajectories are all in front of the court in the exhibit itself. Again, 2 o'clock to 8 o'clock. So the defendant shot while up above, Your Honor, and he shot from this position on the trunk of the car. His boot prints match to his brand, the boot prints that were found, and his size. In fact, he's crouching over the light bars, as can be seen in the photographs that are provided to the court. He's shooting into the 2 o'clock position, and this is the 2 o'clock position. There are 14 of those bullet holes from the 2 o'clock position. Others could have missed, others could have gone into the windshield, Your Honor, in the passenger window. But we know that there's 14. So we know he's up above and he's shooting. And we know that he has to reload. That's consistent with the testimony from Officer Sobolik that he is actually on the hood. He's not only on the trunk, but he moves to the hood. trajectories, Your Honor, that were on the Mondo pad in front of you. These trajectories are at 2 o'clock. The A pillar, negative 22 degrees and negative 21 degrees, consistent with the position of being up on top of the zone car. We have additional shots. At 1 o'clock, negative 29 degrees. At 2 o'clock, negative 14, right from the one that we talked about through the mirror. And again, you have bullet hole 91 with a trajectory placed into the top of the roof liner at 1 o'clock. Negative 10 degrees, significant because of its height here, the tallest portion of the car before you get to the roof. No one else can be doing that but the defendant, Brelo, in his position. Again, this is looking at it from inside those same trajectory rods. 2 o'clock, negative 14. 2 o'clock, negative 19. 2 o'clock, negative 7 degrees. This is the negative 21. These trajectories support that he was shooting numerous times while he was on the zone car. We know that he had to move down and shoot because this is his second reload here. He reloads then while he's in an elevated position in transitioning down to the hood of the zone car. There are 1 o'clock trajectory holes and 12 o'clock positions that support his movement and his shooting. And going to those specific bullet holes. The state's position is that Brelo is responsible for all of those lethal shots. Again, 1, 2, 8, 9, 10, 11, 12, 13, Malissa Williams, 1, 2, and the 15 series for Timothy Russell. Under the law, not that a specific shot, Your Honor, must be proven as a kill shot, as the law is contribution to death, as the medical examiners each testified to, including Dr. Rowe. The other non-lethal Brelo shot hastens death as well. As to the specific shots from the hood itself, Mr. D'Angelo had asked that question. So let's go down the rabbit hole for a moment here. The defendant's position on both are unreasonable. But you can determine that he, in fact, was shooting and hit the bodies while he was on the hood itself. After the state's case, the defense's own experts, in their own testimony, confirmed Dr. Philo and Ween's testimony and solidified the hood shots. It's here that I would argue you have specific wounds, even lethal ones, Your Honor, in and of themselves, so that's not the law, that the defendant caused. Clearly, there's a difference in the testimony between Dr. Weens and Philo on the one hand and that of Dr. Rowe on the other hand. Weens and Philo offer the court definitive testimony. Ante-mortem versus post-mortem, alive versus undetermined, while Rowe's testimony lacks the weight. They did the autopsies. They were at the scene with the bodies when they were recovered. State's Exhibit 1228. They saw the bodies in the position that they were in. Dr. Philo and Kurt Jones placed the trajectories inside of the mannequins and then actually took them back out to the scene when they were located back in the same position using BCI's technology. Dr. Philo testified for the court that the A-pillar shot did in fact cause wound number 10. That places a wound, and it places a wound at a position where the defendant, Brelo, was. So we know his position at that o'clock. It's 2 o'clock. Their testimony was definitive. After all, they did the work. Dr. Rowe did not know about wound number 2, the Timothy Russell, that is the difference in the trajectory. She made no comment as to the trajectory position. She would agree or not. Number 11, Malissa Williams. Her opinion, as she testified, was different than the other doctors reviewing the documents, including Dr. Posey, she said. That number 11 is a 4-inch downward trajectory, and the autopsy records will make clear to the court that this number 11 is a significant steep angle. In fact, number 11, the bullet hole comes from left to right. Testimony from Dr. Philo was that those bullet holes 9 and 11 go from left to right, both of which are found in the back of Malissa Williams when the autopsy was done. 9 and 11. 11 being significant, as is 9. Significant downward trajectory. But Rowe had a difference of opinion on that. The state would suggest that people that do the autopsy here to the court actually knew better. Dr. Philo himself, in doing that autopsy, was very clear that it was a downward trajectory and that it was steep. All right, Dr. Rowe, although she reviewed things on paper, never called Weems or Philo, even though she knows that they in particular have an open door policy, like herself. Why? She says because she never does if it's a case that's going to trial. But also she never reviewed their testimony, even though transcripts and live streaming is available, and even though all experts are invited to look at the other experts and even be here in the courtroom. All of the undetermined wounds Dr. Rowe ruled as peri-mortem. She cannot contradict the testimony of Philo or Weems. Even the ruling on the ante-mortem shot, number 2, for Malissa Williams, the one that went into the eye, where Dr. Philo said, I saw no evidence of blood there. She would still rule that as peri-mortem. Depending on your philosophy, she's either internally inconsistent with herself or she's just ruling anything peri-mortem that doesn't have some indicia of blood. She would even change or switch a doctor's opinion that he felt it was ante-mortem. So she's looking at it very academically, Your Honor. She has a point of view that if it's not in the documents, or if she doesn't see it herself, that she's going to view it that way and call it peri-mortem. It doesn't mean that their testimony is incorrect. If anything, it means that she doesn't have the information necessary, and her testimony should be given less weight than Dr. Philo and Dr. Weems. But her testimony does confirm a few facts and principles of the state's case. The principles first, Your Honor. The first principle, the verdict of homicide by 23, 24 multiple gunshot wounds are correct. And the way the medical examiners are supposed to rule it, they ruled it correctly. There can be a death by combination of wounds, even if not specific by itself. That is proper. They collectively contribute to the death, as she explained. And she, in fact, has ruled that way herself. Even if it's a smaller wound, it can combine to collectively cause the death. And that's pathology in the law 101. That's what medical examiners rule. And she had no contradiction to their immediate verdicts that they provided. The collective combined wounds caused the death because bleeding hastens death. Ms. Royster read to you the causation instructions. You can be unconscious. This is the second principle. That is, incapacitated and not move, Your Honor. The voluntary movement is gone. When you're shot on the hood, even if not moving, they could be alive. If you're not moving, you could be unconscious. The third principle. The heart is a beating pump. You are alive if you have a pulse. You're alive if you have a beating heart. You can be shot in the head and still be alive. The fourth principle that she confirmed, hemorrhagic wounds are indicative of life. The fifth principle, being shot in the heart, you may also survive and be alive. And here, in this case, she did not do any calculations of the blood volume. She can't say that they were not alive. So we have to go with Philo and Weems when they testified for the court that they were alive on these certain shots. And when they testified that they actually did the calculations, Dr. Rowe did say that you would expect, if wounds occurred on 9, 10, and 11, for that blood to collect in the cavities. And it could be weighed out, and she has done that before in the past. But she didn't do that prior to making her opinion in this case. Some facts now that Dr. Rowe's testimony supports. And these support the number of facts that the state was attempting to show to the court. Martini had a paradigm. This model of Martini's was provided to the court, and that is in fact in evidence, Your Honor. The paradigm report, his own model, it was supplied to her on November 24th, and it went to her before her opinion was written on December 1st. Martini's official report, then, isn't made until January 3rd. Dr. Posey's report, as she testified, she reviewed that as well before her testimony. Then this final report from him came out, she explained, and she had on December 10th. She isn't as independent as the defense had made her out to be on direct examination. So that itself affects the weight, somewhat the credibility, or the paradigm that's put forth in front of the court. What was the parameters? If you have parallel path wounds, you can then explain that the victims were dead at that time because it's consistent with there being parallel path wounds. And then you can explain away the other fatal shots, 15B and D, by saying that those could be done by Diaz. Her parameters were supposedly the way the bodies were found. That's the way that she fully admitted to. She explained that she took into account where the bodies were found and where the bullet trajectories are and where the bullet paths are into the body itself. Martini supplied her with that information. She set the parameters, or they did, so tight that she can do nothing but come back and say what it is that they already are positing. That is, that they were dead already at the time that those shots occurred. She said in her report that Malissa Williams was dead, but she can't and couldn't with any credibility say that here on the stand, because Weems and Philo had already testified that the heart was beating, that the blood was being collected and weighed, and again, Rowe admitted that she didn't do that math. The defense theory put forth by the paradigm report of Martini has that they were dead. Weems and Philo, and even Rowe, the opinion from Mr. Shaughnessy, what he asked her to read her report very subtle. She testified that on wounds 1 and 2, on each of these wounds, that could be from the hood or from the trunk. Can that be from the hood of the Malibu or the trunk of his own car? And the answer was yes. He was including both. And then he had her read her report. Her report specifically was not her testimony. So the experts were hired. They contacted Mr. Martinelli. And this shop is a one-stop shop where Martinelli, as Martini explains it, talks to the client and he directs them what it is that they need to come up with, what witnesses they'll need. And the obvious paradigm that was put forth by Mr. Martini is that there is a defense here because you have parallel wound tracks, and because of that, there's death. Mr. Martini says 5 of the gunshot wounds, specifically A, F, and I, just use the letters from here on, exist similar / parallel wound paths. Gunshot wounds C and E are also observed to exhibit similar parallel wound paths. How about for Timothy Russell? 15 C and E parallel wound paths, 15 B and D are excluded. The remaining shots, 15 G, H, I, F, and A. Those are determined to be consistent with the shots fired from an elevated shooter position. The testimony here was from 238 or from the hood of a Malibu. The paradigm report that was provided explains that these shots here on 10 and 12, these parallel wounds, are significantly different than 9 and 11. The shooter would have significantly changed positions and or point of aim between paired 9 and 11 and those of 10 and 12. Similarly, you have the same thing with Timothy Russell's body. A, F, G, H, and I exhibit similar wound paths. 15 C and E, pointing the other way, are different, but they're parallel wound tracks. These shots here, Judge, are consistent with the change from the trunk to the hood. 9 and 11, which were shot from a backward, front to back, left to right, come down into the body cavity. We went round and round with Dr. Rowe. It wasn't in an attempt to trick her. It was an attempt to explain and have her explain to the court why she put the same language in her report that Martini has in his report. These are the mannequins, positions, and the ones that they're ruling out. They're consistent with the midline shots. 9 and 11 are different than the other significant body changes. C and E are different than A, G, H, I, and F. This is Dr. Rowe's report. Now the third page is where we went through the questions over and over again, where she got this language. She got this language from Mr. Martini. And in the language itself, she explains that Officer Brelo then moved onto the hood of the Malibu. The trajectories from this location were from front to back, very slightly right to left, and very slightly left to right, almost straight on downwards. It's in their own communications with each other. The paradigm, the model that was presented by Martini to Rowe. When Brelo shut down into these bodies, Your Honor, these positions, 9 and 11, are significantly different. He had to be on the other side of the midline of Malissa Williams for these shots to go in. If they want us to go down the rabbit hole and explain to the court exactly what unreasonable shots that he also had from the hood, it's 9 and 11. And what unreasonable shots did he have from the hood on Timothy Russell? You have A, you have I, G, H, F. Those are the shots that were developed in their review, the defense's experts' review of the state's evidence. At the very least, the defendant is guilty of committing voluntary manslaughter on both Malissa Williams and Timothy Russell on the hood of the car with these shots. And Dr. Rowe, in her own testimony, explained how she had mixed up the left and right in her testimony, not in her reports. And she was asked, is it possible that wound number 9 is from the same shooter but from a different location in this scenario, moving from the zone car over to the hood of the Malibu? She said no, because when I spoke to you earlier, I got left and right mixed up, and these are coming from left and not from the right. If it's moving over from the zone car to the hood of the Malibu, they are going to be coming from the right to the left. Again, on 4160, the next page, then you have the possibility that there's a shooter that's on top of the trunk of the zone car, as well as on, then later, on the hood of the Malibu. Correct. Because of the position change of the shooter. The defense's own theory from their experts show the position change. So there's a need to go into what's on the trunk versus what's on the hood for the court, to go down that rabbit hole, which the state does not think the court needs to do. We believe that the evidence is present and it's solid that there's been a position change, a significant position change. It's also supported by the audio, a significant position change. So these are Rowe's own reports that we blew up. And again, for the court has them. 9, 10, and 12. She had a difference of opinion on 11 with the doctors about the trajectory on it. But even 11, if you read that, you've got the left to right, front to back, downwards. Left to right, front to back, downwards. Left to right, front to back, downwards. And again, the same for 12. Left to right, front to back, downwards. These are coming on the other side of her body, and the shots are landing over the midline, showing the parallel. Showing a significant position change on the back of State's Exhibit 28. Same thing, Your Honor. In her testimony, she also explained the same thing for 15A And C, E, F, G, H, and I. All of these, which are contributing wounds, are in a significant position change according to their own trajectory, people. Just to go over Dr. Thelo's testimony on numbers for Malissa Williams. 8, 9, 10, 11, 12, 13, alive. It says on 12, most likely alive, page 2105, tearing armed. So for 8, on page 2076, alive. 9, 2079, alive. 10, 2088, the A-pillar shot alive. 11, 2104, alive. 12, most likely alive. 13, alive. 15 as well. This is in the right inguinal pelvis area, front to back, upwards. And then for Timothy Russell, the 15 shots. Again, I'm going directly to where the defense is, where there's an intersection, Your Honor, of facts, from the state's case to the defense case. So when you're thinking of it, someone who's in your position, you say, where is that intersection? Where does the theory and thought, where does it meet with facts on both sides of both tables? Where do they come together? 15A, B, C, D, E, F, G, H, and I. All are alive, or the specific wound is undetermined, but there's the testimony that they're collected, as Dr. Rowe even explained. Judge, thank you for your patience on that. I know that that's specifically, there's a lot of detail there. Because she could not testify to what was in the original report, that they were both dead at the time. There's testimony about them being incapacitated or alive. So she herself, I think, was very forthcoming in her testimony. But sometimes, at some points, we have to go a bit around and around. Each case, Your Honor, beginning with the Garner case, defines the expectations and the definition of a regional police officer's actions. Mr. D'Angelo brought up the White case. The White case was upheld on sufficiency. It was reversed on jury instructions. On the Plumoff case, the Plumoff case came out before the case was indicted in the grand jury. That was known, and the Plumoff case supports the indictment. There's been a stop in the action. There was a stop before the defendant, Brelo, started shooting again, after he reloaded. This reloading from this position is preposterous. It's not just bizarre. It is, in fact, preposterous. In the Jones case, that's the monster truck case, the defendant was still driving that truck on top of the officer. Here, there's no perception from the defendant, Brelo, that they were still moving or they were still driving. The defense in this case proposes a new standard for what's objectively reasonable. In a chaotic situation, anything goes. An officer can leave cover, expose himself to the very danger that he sees and the danger he fears. And if there is indeed a threat, endanger both himself and his fellow officers. He can fire his weapon, even if he can't see what he's shooting at. He can keep shooting, even if he can't see what he's shooting at. Even after his fellow officers have stopped, even after there is a call to cease fire. He can shoot point blank at the suspects who are surrounded with absolutely no chance of escape, with no opportunity to surrender. I think the court will look at both of the positions, both of the victims and their positions in the car and their actions separately. If Timothy Russell was the driver of this car, if Malissa Williams, who clearly cannot get out, although Brelo doesn't know about the C-clamp, there's no way for that passenger to get out of that car. None. And there's no reason to jump onto the hood of the car and expose yourself if you believe that they have a gun and they're still shooting. It defies all logic, all common sense. It defies all reason. He can shoot at them as if they're fish in a barrel looking down into the barrel area, not human beings with rights to due process. By the testimony of the defense's witnesses at this trial, all that is required is for the officers to say that he's in fear of his life. And then all police tactical training, all rules of common sense and decency can be thrown out the window. Anything goes. That's their definition of how a reasonable police officer can behave. But this court will decide if that is truly reasonable. Is that behavior that we as a society governed by Constitution and laws want to sanction? Police work, no matter how dangerous it is, obviously is not war, and we're not at war with our citizens. And anything does not go, and that's not second guessing, it's not Monday morning quarterbacking, Your Honor. That's not unreasonable or irrational. It's simply the rule of law. None of the cases cited by the defense have an officer shooting from above on a car. The pendulum swings too far when a police officer leaves cover and seeks elevation, as he admits he did, as he admits he was trained in the military. It's egregious when he jumped to the hood, their hood, a citizen's hood, the same one that he was supposedly scared of. If this is okay, anything can go. There are no parameters. And we, the citizens, Your Honor, we need this rule of law. We need our police to be held accountable the same that our citizens are accountable. Thank you for applying the standards that you know are present in the law. Thank you for your patience with our arguments. We believe the defendant is guilty of both voluntary manslaughters, Timothy Russell and Malissa Williams. Thank you, Your Honor.
Thank you, Mr. Bell. We'll give a final word to Mr. Gutierrez.
Just one moment, Your Honor.
Are you still working on about the same time estimate?
I'm going to be fast, Your Honor. I anticipate 15, 20 minutes.
Hold on one second. You okay, Rob?
Yep.
All right, so we remain on the record.
Thank you, Your Honor. May it please the court, members of the state's trial team, members of the defense team, and Your Honor, I've been given this opportunity to say the last words in this very important case. It's not only important to the defendant, but also to the community. Judge, before I make my final remarks, I would like to thank the members of the defense team for their professionalism. I would also like to thank the members of the trial team for their dedication and hard work in presenting this case to the court. I'd also like to thank the court reporters. I know it's kind of difficult sometimes when I talk to take everything I say. And obviously, I want to thank the court for its time, its patience, its indulgence. And Judge, you've been here for over 4 weeks. You've heard a lot. What I'm going to try to do, Judge, is hit some points that I believe the court needs to look at and consider when it's giving its final determination of guilt or innocence. And I want to preface my remarks, Judge, on a couple of things. And one is, you being the trier of fact, like I would any trier of fact, is to use your common sense, just your basic common sense, when evaluating this evidence. And to put things in context. And let's put this in context for a minute. I don't think there's anybody in this courtroom right now that would deny how dangerous and hard it is to be a police officer in the day and age. It's a very difficult job. And when we say the Cleveland's finest, that's what we usually mean, because they are the finest that we have of our community. Usually that applies. So this case is not about bashing the Cleveland Police Department. It's not about bashing the cops. It's about holding this man responsible for his actions, like anybody else in this community. Anybody else does an act, they're responsible for that act. And that's what we're talking about right now, Judge. His actions on that night. And Judge, I've been here for many, many years. I've worked with many, many police officers, and I can attest to their integrity and their just being good people. I've been privileged to work with a lot of good police officers. But Judge, as a police officer, as a society, we give them a badge and we give them a gun. They have the ultimate power we give them. And that ultimate power is to actually take a life when it is necessary and justified. And that's what we're talking about today. So what we're talking about, Judge, is making Officer Brelo accountable for his actions. There has not been one piece of evidence. There hasn't been not one suggestion this man is a bad man. Not at all. But Judge, what he did was make a bad decision. And that decision was a deliberate, conscious decision to move up to an elevated position and jump on a hood and kill Timothy Russell and Malissa Williams, Judge. So, Judge, I want to make sure that we're bringing the context clearly in this particular case. Accountability. Because we as a society and we as a community give these officers a badge and a gun and that ultimate power, but we give them training. We give them training because it's important that they're trained correctly. So when they face dangerous situations, that they know how to act. And Judge, using your common sense for 1 second, it's obvious that they can't train for every particular situation because every particular situation is unique. But what is the same in all those situations, and I'm talking about the deadly force context, is that they're dangerous. So, Judge, I want to take one step back for a second. Just one step back. And think about for a second the chase. Think about it for a second. There's 62 police cars, 100 police officers, unprecedented in this city, in this county, unprecedented across the country. Maybe Mr. Martinelli said in California, but strange things happen in California. But the point is, this is unusual. This is out of the ordinary to have such a chase of that magnitude. And when you step back and look at it, you go, holy cow! How did this happen? How did all these police officers get involved in this? We have people going from the gym. We have people coming from the districts, all joining in. And Judge, you may ask yourself, well, Mr. Gutierrez, what has that got to do with what happened at the scene right here? And Judge, it has everything to do with what happened at the scene. This particular incident, this particular tragedy is unprecedented. And what was going on in the minds of these individuals, these police officers, when they were chasing? I'm sure they experienced fear. Your common sense would say, sure. Excitement, adrenaline, and maybe even anger. How dare these people shoot at the police? How dare these people run from us? I don't know. We can all speculate, but if we use our common sense, those are all logical type of feelings that anybody would have. But these are trained professional police officers. When these emotions start getting the better of them, their training is supposed to take over. And I'm not going to try to repeat anything, Judge, because you have been right on as far as listening and the issues in this case. But Judge, what occurred was that buildup of that adrenaline, that buildup of those emotions occurred while they were moving into this particular spot. It was like a crescendo. It was building, and you can feel it. You can feel it by those CAD reports. You can feel it when you hear those particular broadcasts. The officers are excited. Got out of his car, shot out of his car. That's reasonable, that's fine. Saw the car hit, moved to the back of the trunk, elevated his position, then jumped on a hood and shot 15 times into that windshield at point blank range at the victims. Point blank. But Judge, I think what happens after this is so important because, Judge, you heard why is there this distinct cause? Because everybody saw him on the hood and stopped shooting. Look here for a second. How could Demchek and Erg and O'Donnell not see this? Not see coming down the hill and seeing this? How could Patrick and Box and Moore, and let's give them the benefit of the doubt, Judge. Let's use our common sense like I've been asking you. Maybe Sistick was still on the ground after having that harrowing experience of having that car come up, and maybe Moore was a little bit dazed after shooting the ambush training, but the majority of these people had to see it. Because let's even go with their experts and say there was tunnel vision, which all of us have experienced in stressful situations. Who's right in your tunnel vision? Who's in that tunnel? Officer Brelo is. And I'm telling you, Judge, when that happened, when all those people stopped shooting, I'm sure these police officers are going, holy mackerel, one of ours is on the hood. And that's not good. And Judge, you've heard this term called the blue wall, and again, that's very incendiary. But you want to say conspiracy of silence? I don't know what you want to say. But Judge, use your common sense about human nature. All of these people, somebody besides Officer Officer Sobolik had to see this. But he was the only one to see. He had an argument with Officer Farley about that. They argued. But right at the time after this shooting, right when it occurred, and afterwards, there was this first brick in that wall that we're talking about. Because they all went back to the school for 5.5 hours. Now all of us here, we'd have been in this event. We would have been talking about it. And there's nothing wrong with that, Judge. That's human nature. Holy mackerel, did you see what just happened, what we did? I'm sure they talked to their family, they talked to their friends. Sure, I'm sure they weren't talking about the whole 5.5 hours, but they had to be talking about it, and there's nothing wrong with it. But none of them told Detective Holcomb from East Cleveland, hey, we saw somebody on that hood. Nobody said that. Does that make any sense to you, Judge? Use your common sense. Somebody had to see more than just Officer Sobolik. Use your common sense, Judge. I implore you throughout my whole argument. Because it doesn't make any sense. None whatsoever. And then Officer Brelo tells Officer Sobolik that morning, hey, I was the one on the hood. Then he tells Officer Ketter, I was the one on the hood. So there's that first brick, Judge. And what I would call that, it'd be a consciousness of guilt, collectively, by the police department. They knew that was wrong. And I'm going to give you an example, Judge. If Officer Brelo came up on a bank robber who had just shot and killed the security guard, and he was coming out the door with the hostage, and Officer Brelo was able to disarm or kill him, we would be giving him a medal of commendations which he would deserve. If Officer Brelo did something truly heroic, it would have been out there. Everybody would have been saying how great Officer Brelo is. But that's not what happened. There was this brick that started to lay. Now, I don't know whether, I have no evidence that it was orchestrated. I have no evidence that people got together. I don't know if people had a sense of loyalty or there's some type of code. But the fact remains, Judge, that this obvious and commonsensical fact was never told to anybody because everybody knew. Geez, Officer Brelo kind of messed up. And how do we know that? They can spin all they want the text from Officer Hummel. I believe that really tells the story of what was going on right after that. There was a lot of chatter among everybody at that point in time. And everybody knew, oh boy, Officer Brelo's in trouble. Now, Judge, there was no gun. We can probably all agree on that. There was never a gun. But those officers at that point in time knew getting up on the hood, too much. On the trunk and then the hood, way, way too much. So there's this brick, Judge, that starts to be built. And it builds. Officer Sobolik on December 5th finally tells, not finally, but he tells BCI what he saw. On December 4th is when we get a footprint off the cars. So we know somebody's up there. And then what happens? Officer Brelo's statement is crucial to this case for what he says and what he doesn't say. He conveniently forgets he was up there. Now, does that make any sense to you, Judge? Is that common sense to you that he would tell two people right after it happened, and then 10 days later, I don't remember? And even if you want to follow Dr. Johnson's logic, that this could happen, whatever you want to call it, amnesia, memory loss, malingering, whatever you want to call it, Dr. Johnson says at some point in time down the road, you're going to remember. There was no ever any more interviews with Officer Brelo where he said, I was on the hood. So, Judge, there's your individual consciousness of guilt by Officer Brelo right at that point in time. So you have a collective consciousness of guilt. You have an individual consciousness of guilt. We have the wagons being circled right now. And that, as a society and as a community, we should not tolerate. We have to hold everybody, whether you're a police officer or an astronaut, accountable for their actions. And that's all the state is trying to do right now, Judge, is hold him accountable to his actions. So we're at Officer Brelo's statement. So he denies he's there, or he doesn't remember. Doesn't deny, he just doesn't remember. You see the quotes. And this is where things started really to go sideways. Because, Judge, as we speak today, the union feels betrayed right now that their men went and cooperated with BCI, and not only Officer Brelo, but 5 other people got indicted. They feel that somehow they got double-crossed. Objection. And
based on what evidence?
Well,
this has to be a reasonable inference.
And the reasonable inference is this, Judge. They sent out an unprecedented letter to all of these police officers saying, you don't have to talk to the prosecutors. And as well as you know and I know, they're right legally. You don't have to talk to the prosecutors. Nobody does. But you've been around this courthouse for years. You know as a matter of course, as a matter of procedure, that police officers talk to prosecutors all the time about the cases. So the union sent out this letter. There's this consciousness of guilt going on, Judge, to try, for whatever reason, to not let the process go through. If, in fact, there's a disagreement with the charges, then this is why we're here right now, in front of you, for you to decide who's right and wrong here.
But who do they feel double-crossed by this? Their fellows in the executive branch of government, namely you and your colleagues, or their own colleagues?
No, but they cooperated with BCI, understanding and thinking that this was a justified shoot, and then what happened was after the investigation, people got indicted. Okay, that's a real thing going on right now, evidenced by the letters, evidenced by the individual officers who said they got the letters, evidenced by these officers who would not talk to us before trial. This is unprecedented, Judge.
But for purposes of your argument, it's the fellow law enforcement agents at BCI who double-crossed them?
No, Judge, they feel that probably the prosecutor's office did.
Pardon my interruption.
Okay? I don't know. All I know is, Judge, I've been here many, many years. I've never, ever seen a letter like that go out by the police union telling the police officers, you don't have to talk to the prosecutor's office. No, I've ever gotten letters from attorneys telling me, my client, strike that, Judge. I've never had police officers not come and cooperate with me on a case. So this goes to this consciousness of guilt, collectively and individually, that I've been talking about. I think it's important, Judge, because it tells us a little bit about the mentality and the culture of the CPD. They are extremely talented, courageous individuals in that force. I've worked with them. Some of the most amazing people I've ever seen, but this activity and this behavior does not help anybody. I process the system. And I always wonder to myself, what happens next? That's for another day, Judge. So you have this whole dynamic going on, Judge, of Officer Brelo knowing, and the police officers knowing, and there's evidence of all this, especially through Hummel's text. Officer Brelo went too far. So, Judge, we presented evidence to you. We presented experts to you. Mr. Caceres, who Mr. D'Angelo conveniently likes to take out of context things, okay, and try to, I don't want to say misrepresent, but not tell the whole story, maybe by omission. And I know you've listened to the evidence, but I just want to read this one sentence that Mr. Caceres said. He says, even when shooting as he exited his patrol vehicle and sought cover behind another zone car was reasonable. So nobody's doubting his shooting from here to here was reasonable. And going from here to here was objectively reasonable. Nobody's got a problem with that. I don't think anybody's ever argued that. In fact, Mr. Caceres said, if he stayed behind here shooting, that would be okay. And we wouldn't be here if that happened.
Why would it be okay?
Because he was in a position of enhanced safety by Mr. Martinelli behind cover. And
what would have given him the right to shoot from a position of enhanced safety?
His perception, Judge, of gunfire coming from this way. So if he had stayed behind here, of enhanced cover, okay, and this is what I'm going to get at, Judge, and this is one of the main issues of the case that you have to decide. No doubt about it. Why was it unreasonable for him to jump on the truck and then the hood? Because, Judge, it goes to the fact that he had time to assess the situation. Now, the defense wants to tell you, well, there's this compartmentalized time frame and there's bullets whizzing around. That's all true. But he had time to know that there were people on this side, his fellow officers, shooting. He had time to know that. All right? He had time to know that if he kept shooting this way, he might shoot people here. He was aware of the crossfire. He was aware of this, of these individuals shooting there. And he says, this third reason, Judge, was I don't want to be pinned underneath the car. Now let's use our common sense for 1 second. No way this car is going to pin anybody under here. If this car goes straight, it's going to crease the car and keep on going. It's not going to pin him under the car. Okay? So he was behind here, Judge. Yes, they want to say split-second decisions. He had time to sit there, and again, this is Mr. Martinelli's term, enhanced safety.
behind cover. Okay? So what's his explanation of why he elevated? Well, I didn't want to be in crossfire. He put himself in crossfire. Is that logical? Is that common sense? He put himself into crossfire. And in fact, if he was going to get pinned under the car and he was here, he'd get knocked off. So both of those reasons are not reasonable, are not commonsensical. He puts himself in crossfire, in direct crossfire. These individuals here are shooting. It's a miracle, Judge, an absolute miracle. None of our police officers were shot. A crossfire was occurring. So, Judge, I'm saying to you is when he was behind here, he had time to assess. He didn't have to act like that. He could have waited seconds. If he'd have waited 5, 10 more seconds, the shooting would have stopped. And Judge, what is really telling, really telling, and I think you should consider this strongly, what did Ken Caceres say he would have done? He said he would have gone behind here. What did Mr. Martinelli say? He would have gone over here.
And kept shooting.
Yes. Yes. Absolutely. And that would have been reasonable. Okay, because that's, and again, now we start talking about, well, how do we know somebody's reasonable or not? What criteria is the court supposed to utilize to determine what is he reasonable? What would an objectively reasonable police officer do in that situation? And I submit to this court, you can bring 100 police officers in here, you can bring 1,000 police officers in here, and everyone's going to tell you, I'm going to go over here. I'm going to go over here. So what did Officer Brelo say why he did that? Based upon his military training to move up, elevate, and push through a target. His civilian training did not come into effect. And Mr. Martinelli and I could go around and around, and we did, quite a bit. He would not agree with me. I asked him, I don't know how many times, and you probably counted how many times I asked him, being repetitive. Isn't there a difference between military and civilian training? He goes, depends. Judge, there's a significant difference between being trained as a military officer and a civilian police officer. And that's the move he made. It's unprecedented. Mr. Martinelli even said, I never heard of that. Ken Caceres said he never heard of that. And what did Lieutenant Kuntz say? It'd be memorable. Because you don't do that. He was trying to eliminate the target. He didn't have to eliminate the target. You want to neutralize the target. He could have just gone over here. And the defense is going to say, well, geez, Jim, you're second-guessing him. You're 20-20 quarterbacking, and that's not what the law says. No, Judge, I'm not. We're asking our officers, based upon their training, not to be compelled by fear to kill people. When there's other reasonable, objectively reasonable options available to you. And there was. There was these options available to Officer Brelo. But he made that bad decision to get on that hook truck and get on that hook. He made that decision, Judge. And that was a bad decision, and that was an illegal decision. He wanted to kill. There's no more evidence, Judge, of wanting to kill than when Officer Cibola came up and showed you what he was doing. But we're talking about point-blank transitioning into a windshield. That's the kill. Yes, Judge, they had probable cause to believe these people had committed a crime. Yes, Judge, they had probable cause to believe that their life was in danger. That is undisputed. What is disputed is how are you going to react to that probable cause to arrest that people and neutralize that threat? Not by jumping up and killing them. When you have another option available. Officer Brelo knew there were all these officers here. He knew there were all these officers here. He knew there were officers everywhere. And all he had to do, Judge, is assess the situation for a few more seconds, and he would have realized that, hey, my best move is over here. But he had a subjective belief, Judge, that that's what he needed to do, and that's not what the law is. His subjective beliefs are not what the law is. It has to be reasonably objective. They had probable cause to arrest, but when they used deadly force, Judge, our laws throughout this land state it's got to be objectively reasonable. Judge, real briefly, I want to go through Mr. Martinelli. Because, Judge, as you know, experts are come before you. Sure, they're all paid and they're biased to an extent. But, Judge, as an experienced judge, you know when somebody's overreaching. When they overreach, Judge, it diminishes their credibility to the court. It should, and diminish their weight that you should give them. Judge, now I asked you about 20 minutes ago to use your common sense. And let's use our common sense. How do we judge what's reasonable? Where do we start for what's reasonable? Well, I would propose to you, Judge, I would suggest to you, I would assert to you, that you start with training. Sure, if you violate your training, that in of itself is not a crime. But that's part of the equation. Mr. Martinelli said his tactical decision was faulty and would be inconsistent with officer safety doctrine or training. But this is what, Judge, I hate to say it, blows my mind. He says any tactical decision that Officer Brelo made during this engagement, which could be considered to be questionable, are not a component of the calculus in determining whether or not his ultimate application of deadly force was objectively reasonable. What? You mean 2 + 2 doesn't equal 4? Where do we start if we don't start at their training and what tactics they did? That's the starting point to determine the reasonableness of any officer. What were they trained? What were their tactics? And when Mr. D'Angelo says all these people were out of cover, no, they weren't. They were running to cover. Everybody was running to cover, from cover, to cover, except Patrolman Box. Unfortunately for him, he had zoned out and he put himself wide out in the open. But all those other individuals, Judge, were running to cover, from cover. Nobody put themselves out in the line of fire except Officer Box, except Officer Brelo. Mr. Martinelli opined, Judge, for you, there's no reasonable doubt in this case. He opined for you that there was no specific intent. He opined on things that he has no business opining on. He also came in here giving you all these, what you want to say, psychological mumbo-jumbo. We can all agree, Judge, using our common sense, that in this situation we're excited. The adrenaline's going. We could be angry. We could be fearful. All those emotions go through I don't think anybody's going to disagree. But it's how you react to those. As a civilized society, we expect our police officer to act in a reasonable way when that's happening. If it was me or you, we wouldn't be doing that. We'd be kissing the ground probably, praying. But we're civilians. We're not professionally trained. We expect this from our police officers, that they react properly in these situations, these dangerous situations that they face every day. Every day, Judge. Now, you can go into the lighting, into the sound, and you can make your own conclusions, Judge, but Officer Williams said it was dark, but I could see. The sound, Judge, speaks for itself. There is a pause, a distinctive pause. Why? Because everybody stopped shooting, and they saw Brelo, and he kept shooting. That is a reasonable inference on the facts. What occurred here that night? Now, I want to go back to Mr. Martinelli for a second. He said that Officer Brelo's actions were reasonable, objectively reasonable. Then he says, and this is important, Judge, I really could see that Officer Brelo's reaction to his perceived imminent deadly force threat was bizarre, bordered upon negligence, and certainly placed him in a position of increased danger. Judge, Mr. Martinelli just contradicted himself. How could your actions be objectively reasonable and be bizarre, borderline upon negligence? Doesn't make any sense. Again, common sense. Common sense, Your Honor. So what I'm trying to tell you, Judge, the point being is Mr. Martinelli, fine gentleman he is, came over here and overreached to you. Overreached to this court. And say anything you want about Mr. Caceres, he went right to the point and said, and what did he say? He says, anything going above, anything after this point, Judge, was unreasonable. That's what he says. He didn't opine on specific intent or reasonable doubt. He gave you the nuts and bolts, quick, right to the issue. That was not reasonable. We don't train it. It's unprecedented. It's uncalled for. It's all sorts of things because nobody's ever heard of it before. Officers jumping on hoods and unloading the gun. And we get to the psych experts, Your Honor, and Dr. Johnson, very impressive individual, but he can't tell you what Officer Brelo was thinking that night. He can't opine on that unless you talk to the guy. He never did. He never talked to him. And this thing about disassociation, we all experience that, Judge. It's common. But you don't lose your grip on reality when that happens. You get tunnel vision. You might not be able to get your peripheral vision. But as a trained police officer, that's when your training kicks in. I can't act on a compulsion, a subjective compulsion. I can't act on my fear. I can't do that. I'm a police officer. I have a badge and gun. Society has given me the ultimate power to kill. We give police officers that power to kill, but they have to be justified. And Judge, we talk about all of this. And you know, sometimes I sit back and go, what about the victims? What about the victims? Malissa Williams. I mean, you can say, geez, the state, Jim, you're overreaching. You're calling her a kidnapped victim. Well, it's just the point being made, Judge, that she wanted no part of this. She wanted out. She couldn't get out. She wanted out. She was hitting on Mr. Russell. And, look, Judge, these individuals, both of these individuals, I hate people saying, oh, they're just petty criminals. That's disrespectful to them. They were individuals that had substance abuse and mental issues. These are individuals that we really don't want to see when we're walking down the street. These are individuals that fell through the cracks, but these individuals all had families, all were loved, and there's no evidence that they ever had any guns. They were more a danger to themselves that night, Judge, than they were to anybody else. And think about it for a second. And nobody can understand why Mr. Russell didn't stop. We could opine, we could speculate. Why didn't they stop? Well, they didn't. But you don't, and I don't want to be incendiary, Judge, but it's not comply or die. That's not how it works. These individuals did not deserve to die the way they did. Did not deserve to die the way they did. Even if they thought, the police thought that they were shooting at them, which we all know was one big mistake. Unfortunately, it wasn't CPD's finest hour that night. And if you talk to the CPD officers, they're probably going to tell you, yeah, you're right. But they didn't deserve to die like this. It's not a comply or die nation that we're in. It's not that. We expect our police officers to act reasonably. And that's why, Judge, when we get this mindset of this chase, I can't explain the words of how could this happen? How could all of this get out of control? How could our community see something as unprecedented, as tragic as this, for everybody being out of control at that point? And that was the result, right there. And Judge,
My mouth gets dry, and that's usually time for me to shut up. Okay? And you all know as I do, that's the hardest thing for lawyers to do, is to sit down and shut up. And I'm going to in a couple minutes. But I want to reiterate something to you, Judge. When you're evaluating this reasonableness, think about the reasons he said why he did that. And they're unreasonable. Think about the fact that he had a reasonable option. And he had time to do that. He had time to make that decision. But he had a subjective compulsion to eliminate that threat based upon his military experience. That's basically what happened here. He even admitted it. Elevate, push through, eliminate the threat. Not stand back, assess, and neutralize. Those are two big-time different standards, Judge. And Officer Brelo did not do that night. Did not do that. Judge, I started my argument half an hour ago about asking you to use your common sense when you evaluate all of the evidence, and there's a lot of it. But really, Judge, at the end of the day, and you know as well as I do, especially you sitting on that bench, common sense guides everybody in their decision making. And you have a very important decision to make, and your common sense will and should guide you. But Judge, I want to say this to you in my final statement, that our society, our community, demands our police to be trained professionally and act appropriately, especially when we give them the ultimate power to kill. And our community right now, Cuyahoga County, our citizens right now, I believe will not tolerate this type of police activity.
Hold on one second. Let me think about that.
I will draw
the spectrum of a reasonable argument, so overruled.
What I'm trying to say, Judge, is Officer Brelo is accountable to the community. He's accountable to the law. He's accountable to this court for his actions that night. He's also accountable to Malissa Williams and Timothy Russell. And Judge, as an assistant county prosecutor...
Are you saying, though, that those are four different things, the law, the court, the people, and the...
Well, the law and the court can be the same.
In other words, the verdict will be reached here, which, whatever it is, I guess some will disagree, some will agree, but hopefully the participants at least will respect. But then after that, he remains accountable, quote unquote, to the community and to the victim?
Well, Judge, he will always be, in some way, civilly, morally, be accountable. But Judge, if you disagree with how I worded it, what I'm trying to say, Judge, is that the law demands the accountability. And we as a society are the ones that make the laws. So, Judge, as a county prosecutor, assistant county prosecutor, we speak for the victims. I see family from Malissa Williams and Timothy Russell in the back. They can't speak. So I'm the one that has to speak for them. Just imagine for 1 second, Judge, for 1 second, put yourself in the front seat of that Malibu and the absolute horror that they experienced in the last moments of their life by seeing a police officer on their hood shooting them point blank. I don't think anybody would want to experience that. Anybody. Judge, you've heard a lot of things over the last 4 weeks. But what I plead to you, when you evaluate all this evidence, and you use your common sense, and you make the reasonable common sense inferences, you will find that Officer Brelo did not act reasonably when he got on the trunk, especially on the hood, and emptied the last 15 shots into those trapped victims. You will find beyond a reasonable doubt all the elements of voluntary manslaughter has been met. Thank you for your time, Judge.
Thank you, Mr. Gutierrez. You okay, Rob? Are you repositioned? All right, well, I want to thank both sides for their professionalism throughout this trial, with only the very occasional lapse, including in my own, of, you might say, a calm temperament. This was a professionally conducted trial, and I appreciate the state for sharing your resources, Ms. Barnhill, with your opponent. I am in a jury trial currently, and I'm also going to be out of town part of this week. So as I mentioned, I think last week, I do not expect a ruling this week. I wouldn't be surprised if it comes after the end of next week, to be candid with you. I would like a phone number for one contact person from each side. And I'm going to call you and give you 2 hours notice that a verdict is coming. I will deliver that verdict 2 hours after I give you the notice. The only people, well, I'm not going to wait for anybody. I only need the court reporter and the defendant here. If Mr. Brelo's not here when he's supposed to be, a warrant will be issued for his arrest. The verdict will be taken after he's arrested. But I will not wait for a single lawyer or a single proponent or detractor from either side. So that, and I'm telling you that now, that notice can come on any day or at any hour. I'm not going to predict, however, what day or what hour. I am only going to tell you, like I already did, that it's likely to be at the earliest late next week, which would be something like the 15th or the 16th at the earliest. And even if I'm ready then, I may still hold off because of the, I don't even know what it exactly entails, but the presence of some large number of police officers in town. We'll go off the record for a second. Do you have all the exhibits? All right, we'll go back on the record. So I was hoping to get copies of the exhibits. I haven't seen those, but I will say this. Before, designate one or more, I don't care, people from either side to make sure that Mr. Lloyd or Ms. Nunez, whoever they designate, have every exhibit with the exception of the mannequins, the clothes, and I believe I know where those are, and the guns. I'm going to ask the state to hold on to those. If I need to see them during deliberations, I will communicate with one of the lawyers for the state, and of course I would copy the defense and any such communications that I have. I'm betting that I won't need to see a gun, but if I do, I know where they are. Are there any other large-ish tangible items besides the clothing, the mannequins, and the guns?
Well, several, Your Honor. Actually, first of all, the question is, what would you like us to do with the model that's saying you are?
That's become part of the scenery. I'm going to keep that after the
Okay.
Seriously, I would leave it here.
Okay.
If you don't think it's safe, then...
Pardon me, would you like to leave the car, us to leave the car set up for you?
Yeah, and we'll see how many days it takes for them to disappear. Now, I think they should be okay in all seriousness, and I have been looking at it for 4 weeks. I pretty much know it, but I think it can't hurt to leave it here. If you need it for some other reason, tell me and your opponent, and you'll probably be permitted to take it.
Well, we'll certainly leave it, Judge. How about if we do take the cars and put them in a box and bring them to you?
Yeah, I guess that's fine if you think they might go missing. You were going to say what else?
Yes, Your Honor. There are also the enlargements. I don't know if you would like us to leave this up here for you. Or
Yeah,
take them downstairs. They can still be available if the court wants to look at anything. I also, as the court requested, have all of the, let's say, non-bulky physical exhibits on a jump drive.
Oh, I'm glad to hear that.
And I have the paper exhibits as well for the court reporters. I don't know if the court wants to look at that, but everything that's on the jump drive is duplicated. I'm sorry, everything that's in paper is duplicated on the jump drive. Not everything in the jump drive is duplicated in paper.
Right.
Might be also just take a photo, let the parties get the position they agree on, take a photo of it, and just an iPhone, and we mail it to you. That way we only need to leave the cars and the figures.
If your opponent doesn't mind, I don't mind. I mean,
It doesn't matter to me. We don't need a photo, but if the state wants one or the court wants one, we don't have a problem.
yeah, that's fine. Make sure, though, that when you email it to me, you copy one or all of your opponents. Ms. Surratt, have you seen what's on her flash drive?
Yes, Your Honor.
And are they only things that have been admitted?
Based on a cursory review, yes.
Well, cursory or not, a review. I mean,
Yes.
and then what else, Ms. Barnhill?
Oh, nothing. I just wanted to advise the court. I made, what was it, Friday when we were here, made a copy of this as is for Ms. Surratt, so she also has a copy of the admitted exhibits. My only question for you, what I included with hers that I have not put on here, is would the court like a clean copy of the exhibit list of all the admitted exhibits? It may prove useful when you're
Right, I would.
sorting
It'll help
through
me.
numbers.
I know basically the groups of where they are. I know some certain numbers, but that would be helpful. But anything you give to me like that for my own assistance, just make sure you copy to your opponents so that they know everything you're doing.
Very good.
Ron, we can make this easy on the exhibits. Can we just have Erica's professional representation that you've removed the exhibits that have been not entered into evidence?
I have.
And we accept that.
And how about the defense exhibits? Did you make a copy, Ms. Surratt, of a disk or a flash drive or something like that?
I will have one available for the court tomorrow. I will make sure to provide it to Ms. Barnhill first to have her approve it. If she so approves, I will then provide it to your chambers electronically, as well as the paper copies for the court reporters.
And I can't recall off the top of my head, but none of yours were really overly large or tangible other than paper, right?
Very correct, Your Honor.
So before you leave today, Ms. Barnhill, make sure Ms. Surratt leaves with Mr. Lord or Ms. Nunez only those things from the defense that have been admitted. I have a list of them. I'm sure you do too. You can leave the oversized poster boards here. I will have those. I guess the main thing is I didn't want to take possession of where the guns are the guns, and the other stuff, like I said, I know where it is. And I may be done looking at the other non-paper exhibits before I even have a verdict. If I do, I would let one of you know so somebody can retrieve them, and I'm talking about the clothing and the mannequins. And any communication like that I have with you that's administrative, I'll copy probably all of 4 of the other lawyers on. So something else we haven't covered by way of an administrative or similar matter?
I don't believe so, Judge.
No, Your Honor.
All right, appreciate it. We're done. We're off the record. Thank you, Mr. Lloyd and Ms. Nunez. Do you guys have a list of what has and hasn't been admitted? But you're just going to take possession of it and trust that they're vetting it before giving it to you, right?